Hello?
Yeah.
Yes.
Yeah, you can all hear me, right? Okay, it's just shortly after 10 o'clock, and the meeting is scheduled to commence at 10. We're still waiting on one person, Mr. Hall Baird, I think. He was invited, but is not here at the moment. But I think I'll just commence anyway on that. Anybody know his whereabouts at all?
I think we were in touch with Mr. Hall yesterday. Sorry, Mark Scott, legal counsel for the developer, and I think he was intending to join, as far as we were aware, but I don't think he intended to participate too intensely in terms of the PEM itself. So I think he was going to join certainly for a while, was the indication we had.
Right. Well, according to my assistant, he hasn't intimated his presence yet. And I'm conscious that there's several others waiting, and it's past 10 o'clock, and we've got quite a few things to talk about this morning anyway.
Sure.
So unless anybody specifically would wish me to wait until Mr. Hall appears on our screens, I'll just start the meeting. Okay?
Yes.
Right. You've all got by now an agenda for this morning's meeting that was circulated a couple of days ago with 10 or 11 items on. It's quite a fluid situation because things are changing a wee bit on that, and particularly with regard to Scottish Minister's position through Morton Fraser in respect of land. We'll come on to that later. But before we start into the hub of the business, maybe just have some introductions anyway. So most obviously all the names are familiar, but I'd just like to put faces to names and so on. I'm Chris Norman, a reporter appointed by Scottish ministers to determine and make a recommendation on the two waylaid cases submitted by Scottish Hydroelectric Transmission. And I have familiarised myself with the information I have in front of me, so I'm not appearing this morning at cold, but there's still quite a lot of gaps in my own information, really quite a complex issue with plans and so on, and ownerships, etc. And hopefully by the time we finish this morning, all that will be clearer for all parties. So before I talk about the scope of this meeting, if we could just have a round of introductions. I think I can put roles to names in most cases, but if I could ask, I'll just go through the figures that appear on my screen. Gemma, starting with you, your full title is?
It's legal manager for the applicant, Scottish Hydroelectric Transmission. And I also have with me our legal trainee in the room, Andrew Kerr.
He may not be appearing on my screen, but yeah, fine.
He's physically in the room with me, but not.
You can see what's going on anyway.
Yeah.
Right, that's great. Right. Mark Scott.
Yes, morning everyone. Mark Scott. I'm head of legal for Muirhall Energy, which is the group company for the developer interest in this case, which is Glen Wind Farm 2 Limited.
Okay, thank you, Mark. Bill.
Yep.
Bill Dundas.
Hello, good morning. I'm Bill Dundas. My job title is Deputy Head of Area Offices. I work for Scottish Government, Rural Payments and Inspections. My role in this is I have responsibility for the operational delivery of Scottish Ministers' crofting and farming estate, including Brackenvale Estate on Skye.
Right, now come on to that in a minute, because I want some clarification in my own head about the boundaries of that, and that's one of the items I want to discuss later on. Thanks for that, Bill. Mike Mollison.
Morning. Mike Mollison. I'm the head of design at Muirhall Energy. I'm also was senior lead of the Glen project.
And Richard Loans.
Mute.
So,
There we go. Morning, everyone.
thank you.
Rich Flowens, Associate Director at Blackhall and Powys, working as a contractor in the land team for SSE.
So, Associate Director, I didn't catch that company.
Blackhall and Powys.
Okay, thank you. Douglas Mill.
Good morning, sir. I'm a partner at Morton Fraser, and you've already met Mr. Dundas, who is representing our client, the Rural Payments and Inspections Division of Scottish Ministers. And really the point to stress, as Mr. Dundas has already said, is that Morton Fraser, on behalf of RIPID, are representing Scottish Ministers as a landowner.
Thank you. Kirsty Batu.
Morning, everyone. I'm Kirsty Batu. I work at Muirhall Energy. My job title is Project Manager, and I am the Project Manager for the Glen 2 wind farm planning submission.
Thanks, Kirsty. Derek.
Hi everyone, Jerry Morrow. I'm another legal counsel at Muirhall Energy. I've been assisting on this this project on the legal side.
Thank you. And last but not least, Derek. Well, right. I think that's everybody there, and that's great. And got note of that, so I know.
Ali, yeah. Mr. McLeod.
Sorry, Ali McLeod, the lead land manager for Scottish Hydroelectric Transmission, managing the Sky Reinforcement Project, and working alongside Rich Learns in terms of securing the required land rights.
Right, sorry about that. Was that there, Ali? Thank you. I've seen your name obviously in all the papers there. Right, is that everybody accounted for? It's obviously quite a screen full of people there, and I hope everyone can hear and see faces on that as we go through the meeting. And I will make a note of the meeting as after we finish and circulate it to all parties for comment. If there's anything in that note which is incorrectly taken or not a matter of fact, then I would look for people to point that out so we can correct it and we have a finalized version of the meeting. Because as I say, and that brings me quite comfortably to the next item on the agenda, is the purpose and the scope of the meeting. And I say at the outset, today's meeting is not to talk about or debate the ins and outs of a proposal or objections to a proposal or anything to do with the merits or otherwise of Glen 2 wind farm. It's simply just to set out my range of understanding to make sure I've got the correct document and I'm drawing the right conclusions from the array of documents that I've now got in front of me. There won't be any discussions from either party or from myself about the merits or disadvantages of aspects of the proposal. It's basically a fact-finding meeting which will lead up to virtual hearings later on in the year, and we'll talk about dates and so on as we go through the meeting. Next item on my agenda is an update on negotiations between parties. And as I understand it, there's a Mr. McCulloch, who's a principal landowner of 2 parcels of land. One is the small forestry area west of Eden Bain substation, and the other one is the north-south tending woodland, which would lie to the east of the proposed way leave. I've obviously got the plans on there, but I just want to make sure that I'm correct in a basic assumption, and references to Eden Bain substation is that what's actually marked as power station on my ordnance survey map. And the small area of woodland to the west was the subject of WAY-270-23, and the north-south tending woodland is WAY-270-35. Okay. In addition to that, I have the notifications now from Morton Fraser about the Scottish Minister's ownership, which is the land at Brackadale, which is to the west of the small area of woodland and includes the village of Brackadale and some land that runs up to, I'm bound to get this pronunciation wrong, Feoleg towards Dunvegan. And as I understand it, there's a large area of land in Scottish Minister's ownership which is tenanted out. There'll no doubt be crofting leases, etc. And that is where Morton Fraser and colleagues come in. Am I correct in that understanding? Good. Right, that's a major step forward. And the other two, the two way leaves themselves affect the small area of woodland to the west of what's annotated on my Ordnance Survey map as a power station, which I'm assuming is incorrectly meant to be Eden Bain substation. It's not a power station, I take it. That is the land that Halls were representing Mr. McCulloch as landowner on.
Correct on everything, Mr. Norman. The one minor correction might be the landowner's name. It's not Mr. McCulloch, it's Mr. Christopher McDowell that owns the land.
McDowell, yes.
Just
right.
A small point.
Yeah. It's Mr. McDowell. And Mr. McDowell owns that small detached woodland and the larger area of woodland, the north-south tending woodland to the east.
Correct.
And Hall of Dumfries and Galloway act for him as lawyer and made representations to us on the smaller area of woodland, suggesting that some accommodation was in the offing over the course of the summer, and you were expecting objections to be withdrawn from that. But as it happened, that didn't come in. And then in response to the larger area of Mr. McDowell's ownership, we got the formal objections on that. And so far I'm right, I think, so in terms of what's going on there. Right, so just as background, clearly, I think it's sensible that these two cases are conjoined in dealing with this, rather than having individual hearings and hearing sessions for each one, because there's a lot of similarities, none the least it being the same the same piece of infrastructure for the Skye replacement project. So there's a slight delay, I know, because I know Scottish Hydroelectric Transmission were keen to get an earlier start on this, but it does, to my mind, make a lot of sense in conjoining these two matters. I think I'm also correct in my understanding that there's not a way leave application affecting Scottish Minister's land at the present time. Obviously, there's a way leave will go through that land, but there was a way leave agreement between Scottish Ministers and Muir Hall and Scottish Hydro. But Scottish Hydro have now received a notice to terminate that agreement. That was fairly recently. But there's
that's
no
correct, sir. There was a voluntary way leave signed on behalf of the Agricultural and Rural Economy Directorate in November 22, but that was terminated on the 7th of September this year.
Very recent, just last month. Yeah.
Yes, sorry,
Sorry, Douglas.
Sorry, Mark. I just sort of, that's where the Morton Fraser letter of 12th October, just a couple of weeks ago, comes in and explaining just the factual narrative around the termination of the way leave, which was signed by way of an agreement. The application for a necessary way leave does, of course, reference Scottish ministers as landowner, but as a matter of law, a necessary way leave cannot be sought and obtained against the Crown.
Final bit of detail, but yes, that's my understanding as well. And obviously, I have seen the letter from Morton Fraser of last month, and I've looked at the drawing on file showing the extent of Minister's land around Brackadale, and aware that there's no current application before DPEA in respect of that way leave, and it's really a matter parties to move forward on that. Whether another application comes to us or not is not really in front of me at this point in time, but I'm just trying to build up a background picture on that. I have to confess at this stage, I've driven once to Dunvegan, but I haven't seen the site in any detail, and I'll come on to site inspection and familiarization later on here, because I'm seeing a lot just from maps and Google Earth images at the moment, but I'm building up a picture in my own mind of the geography and the land interests there.
Apologies.
So,
apologies to jump in. Sorry, I was trying to put my hand up. I think just a critical point for the developer, and I think also for the RIPIB in terms of the signed way leave. The developer never consented to the grant of the way leave. So I think when it was mentioned there, it was presented as signed on behalf of the ministers and consented to by the developer. That was never the situation. The way leave was only ever signed by the ministers. So it was never a competent way leave, and that was raised with the applicant months prior to the application for the necessary way leave being made. That was a fundamental flaw in the grant of that way leave. And forgive me if I'm speaking on behalf of Mr. Dundas and the wider team, but I think it was all, and we can come on to this perhaps when we give an update, but it was all against a backdrop that this was going to be a formality. And I think from the developer's perspective, it's, and I think they would want me to make this point, we're really reluctantly involved in this public process. We didn't want to be in it, but we're here and we're present. But as I say, I think that there's two important points to note there, which is, one, the developer never consented to the grant of the way leave, so it was never a valid, competent way leave that could be relied upon. And as I say, ultimately, we have been striving with, and again, we can come into that, and if it goes to a full hearing and inquiry session, we'll obviously respond in kind to the kind of timeline submission that the applicant has provided. But I think through the fullness of that, we'll be able to demonstrate that at no point have we ever made the position that the replacement line isn't needed. It was just really the necessity of it is just whether it necessarily has to go where it is. And that's been an ongoing discussion, again, that we can either come on to today if the report is minded to, or we can deal with by way of our own hearing statement. But again, from our perspective, we are reluctantly involved, and there's a lot of things that we would have to then put into the public forum that, frankly, we wouldn't want to be there, given the parties involved in this process. It's effectively is great ammunition for any anti-wind farm campaigner to have a developer, the network operator in Scotland, and the Scottish ministers, just for added good benefit, to all be in a dispute like this. So from the get-go, we've made it plain that this really should not be the situation we're in. Anyway, as I say, primary point is we didn't give consent to the way leave.
Can I just briefly respond to that, sir? Very, very briefly. It's not put forward that the developer consented to the Scottish Minister way leave, but any restrictions on the grant of the way leave by the Scottish ministers are by virtue of an option agreement between the parties to which the applicant does not have access to. So as far as we were concerned, we received a signed voluntary way leave on behalf of the Scottish ministers, which we were entitled to rely on.
Right. Well, for the purposes of this meeting and my remit in this proposal at the moment is that I have two way leave applications in front of me, which you haven't got a signature from Muir Hall. What happens vis-a-vis the way leave westwards from this small area of woodland, if I'm getting my map right, to where it connects with Brackadale and moves northwards to Ardmore and Dunvegan is not in front of me at the moment. Whether or not Scottish Hydro take use other legal channels or whatever is really for another day at the moment. I'm not, part of my remit is not to look at that as things stand.
mean, apologies to
obviously
jump in again. If I may just respond to Gemma's point there. I mean, I think we have both Ali and Rich here, and I think if the applicant's position is they were unaware that there was an option agreement, I think that's fundamentally flawed. I think they knew fine well there was an option agreement in place and that the consent of an occupier would be required. I mean, again, it's up to the applicant to respond to that, but if the position is because that option agreement isn't registered, that they had no way of knowing, that simply isn't the case, because there have been discussions going on for a long time and they would know full well that the site was under option and that a consent from the occupier in that situation is needed. And the point about the consent, I appreciate the applicant hadn't said that, but I was just clarifying because I think it was presented that the developer had consented, and I was just clarifying to the porter that that was not the case. I appreciate the applicant hadn't actually said that.
Really, my last point on this, from the information in front of me, that there's no turbines on land which would have been covered by that on that land. Am I correct? The Muirhall, sorry, Glen Wind Farm 2 does not have turbines in place, or proposing turbines in place on the Scottish Minister's land. It's simply the way-leave and part of the Skye refurbishment work.
No, there are turbines on the Scottish Minister's land as well. In fact, Kirsty, you can perhaps correct me, I think the majority of the turbines may be on Scottish Ministers.
It's almost an equal split between the Scottish Minister's land and Chris McDowell's land.
Right. Okay, well, I'll come on to the details of Glen 2 later on in the agenda, because again, I've only seen very much skeletal information on that, and it hasn't been formally brought in front of me in this context. And again, I would stress that I'm here today to look at the 2 way-leave applications and not the merits of the wind farm itself. That's a separate entity, and it's only its impact on the way-leaves that I'm looking at the moment. But I certainly would welcome, and I'll come onto this in detail later on, I welcome a drawing showing where on the Scottish Minister's lands at Bracketdale the turbines are included. Excuse me. As I say, I'll come on to that in a wee while. Okay, well, we're still talking about the scope of the pre-examination meeting. As I say, this purpose this morning is just to do exactly what we've been doing in the last 10 minutes or so, is to establish that I have all the information relevant to the consideration of the 2 way-leave applications and any associated background to that. Unless anyone else wants to raise anything under item 2 there, I'll move on to item 3.
I think, sorry, apologies me again. I think the final point, you've touched upon it already, and the developer wasn't sure whether it would form part of the scope of the PEM as described, but certainly the position with the Scottish Ministers is obviously a significant change from when the applicant made its application and from when it submitted its hearing statement. And I think that is ultimately, from a legal perspective, going to form a significant topic for discussion at the inquiry. So I appreciate that there is some focus on the kind of update on proposals from Glen Ullinish. As you say, that's separate, but was intrinsically linked to the necessary way-leave is the section 37. So I think it is going to be fundamentally important itself from the developer's perspective, and I would imagine for informing the decision by the decision makers, the Scottish Ministers, as to how exactly the applicant here would propose to overcome and validly secure those rights for the proposed reinforcement, because I think in absence of that, then there is no prospect of them developing out the line as proposed. So I think that's a really critical legal point that would have to be explored at the hearing. And as I say, happy for the applicant. As we mentioned, the parties here have known about the position with the ministers for some time, so it may well be, Ms. McMillan is in a position to respond to that today, we would of course be happy for them to update either their hearing statement to set out exactly legally how they would propose to address the situation that Mr. Milne so eloquently provided to everyone. So whether that's, as I say, but that would certainly be for the developer a significant change and material factor in terms of how we would respond to the applicant's proposal.
Would question to what extent that discussion is relevant. It is something which the applicant is considering internally. I didn't automatically jump in, but the applicant does not concede that it is prohibited from raising an application against Scottish ministers, and we believe that there are routes to do that. But in the current circumstances, and Mr. Scott has already clearly alluded to it, I don't think any of the parties are particularly happy to be in this position. I think we're hopeful, and we'll no doubt come on to that in terms of the next agenda item. We are hopeful for an amicable solution to be reached, in which case we don't believe that there, as we understand the issue with the Scottish Minister consent and Mr. McDowell consent relates to the option agreement. If a voluntary agreement is reached with the developer, we're hopeful that voluntary agreements could also be reached with the Scottish Ministers and the landowner, Mr. McDowell.
Okay, thank you.
Just from our perspective, our understanding is that it's kind of standard practice when you apply for your Section 37, you would include the areas or sections of land that are required to be secured by way of necessary way leave, so that when the ministers make a determination on your Section 37, and they're also making a determination in terms of depriving landowners of their land holdings, then they would want to know that when they do so, that the line can then be properly constructed. So I think it's difficult to kind of separate the two if you're looking to proceed by way of a necessary way leave to secure and deprive Mr. McDowell of his rights, whilst you have a significant gap and legal obstacle there in which to secure the entirety of the route. I think it's difficult from the developer's perspective to see how that can be separated.
I wonder, sir, if this is the appropriate place for this discussion to be taking place, or whether it's more appropriate for it to be discussed within the realms of the hearing itself.
I think it's certainly not relevant to talk about at the pre-examination meeting this morning, because obviously this has all happened fairly recently, just last month still on that, and it may well need an amendment to parties' hearing statements to include it that, and when that is done, either opposing parties can look at that and see that, and we can have a session on that later on at the hearing itself. I don't want to go through the detailed filigree of this issue at this point in time. I'm aware of the issue through the Morton Fraser letter. I'm aware of the location of it, and I'll come on to this later, but I need much more information on Glen 2 wind farm than what I've got in terms of where, in particular, the turbines are. But I'll come on to that in a minute. But I don't want to go and discuss the position of Scottish ministers as landowner in this PEM, which is really going to make a recommendation to Scottish ministers as regulator at this time. So I think the way to handle this, and I put this in my note of the meeting, the way to handle this would be an amendment or an augmentation to parties' hearing statements, which I'll come on to as things stand as well. Is everyone happy with that approach?
Yes, thank you.
Okay. I suppose, sir, just from Scottish ministers as landowners or position, obviously you don't have a position statement from RIPID, you just have the Morton Fraser letter. RIPID have got no desire to participate in the procedure in a formal way, and my instruction is to be here to assist insofar as I can by answering questions. So just maybe a suggestion when it comes to the preparation of a procedure note following this meeting is if you have any specific questions for RIPID, we'd be very pleased to answer those. As I say, we don't actually have a position statement to update and are not intending to produce one. So if you do have any specific questions, as I say, it may be helpful to direct those to us.
Yeah. And in the meantime, I will assume that discussions may take place between Scottish Hydro and Morton Fraser away from these offices at this point in time, and they may arrive at an agreed position, they may not.
Yes,
this is not the forum to discuss that.
Absolutely. I'm very pleased to participate or facilitate the discussions between the parties insofar as it's appropriate for RIPID to do so, given their role.
Okay, any person got any comments on Mr. Millen's and Ms. Macmillan's points there, that there may well be discussions away from this particular procedure, looking at the two way leaves that are in front of DPA at the moment, and that may lead to an augmentation of the hearing statements for the hearing itself, which follows later on, and we'll come to that at the end of this meeting. Okay. Right, which brings me neatly on to item 4, participation. And clearly I would assume that both Muirhall Energy Limited and Scottish Hydroelectric Transmission will be participating. Morton Fraser, on behalf of Scottish ministers, may or may not, depending on how that's reflected in hearing statements of parties who are participating. And clearly, if there was a wish to participate, be an approach to myself, and I'll respond in appropriately on that. Okay, and as far as I know, there's no members of public going to be participating, and no other landowner interests. I'm just a bit confused about the position of Mr. Hall, insofar as he was talking about particularly the way leave in the western woodland compartment, and objected, but he was made aware that I wanted to deal with that via a hearing. Still haven't had a response, and I'll come on to that. But I still haven't had a response to the procedure notice, the request for further information in respect of way leave 270-23. I have a full one in respect of way leave 270-35, and I'll come on to that in due course this morning. But I'll need to find out what the position is with Hallbed on that, and we'll pass that on in a minute of the procedure notice, just for parties' information. Okay. Right. Item 5 is structure for the hearing and structure of the evidence and estimated timescales. And what I'm looking to do is hold the hearing itself virtually. I know persons may wish face-to-face hearing, but certainly given the geographical range of ourselves, etc., I would tend to go for the virtual procedure. Does anybody have any observations on that? Anyone would prefer face-to-face? No. You're all happy with that? Right. So that's good. I've got, obviously we've got a lot of pressure on just our ability to host this at the moment, and the statutory timescales, etc., to deal with. But I was looking towards the end of November for the virtual hearing, around the 28th, 29th and 30th of November. I would wish to see the sites before then, because it's much more easy in my own brain to know what I'm talking about physically, and rather just from photographic representations and maps and so on. And that is an easier item to arrange. I think I want to be accompanied on that, and certainly get access to some of the more remote parts. And I'm conscious that we're coming up to probably the worst time of the year to do that. And that's obviously going to be very weather dependent as well. But does anyone have a problem the 28th, 29th and 30th of November?
Just in terms of the dates, sir, I wonder whether it may be. I'm very conscious that negotiations are going on between the parties in the background. I'm sure Mark or Derek will jump in and stop me if they think I'm incorrect, but there, as far as I'm aware, we have an agreement in principle, and it's now just a matter of having that documented and some discussion around the exact wording. But if the hearing was perhaps to move into early to mid-December, that might give parties a little more time to get the agreement documented.
Yeah,
Unfortunately,
well-
Chairman, I am told that December is clear, but obviously our IT team are wanting to make sure that the slots that they've got are used in a progressive manner. But I'm told that, save the last week of term, if you like, before the Christmas holidays, we could be available in December for that. But if you could let me know pretty soon so I can make that booking, because I think it may well take more than a day, the way things are going at the moment, because I'll come on to that and sort of things I need to find out. But there is the possibility of having the hearing in December. I estimated it may well be 3 consecutive days, given the volume of information I've got in front of me. I'll come on to some of the more detailed aspects I want to see and talk about just further down the agenda here. But that's not unsurmountable as things stand at the moment. And clearly, if there is the prospect of a resolution to this, and that could cause the withdrawal of the objections, that's in everybody's interest in terms of timing, etc. So as things stand at the moment, it's not unsurmountable to have the hearing in December. And I'll put in my note suggested dates, probably the middle of that month. So I wouldn't like to be doing it just the last week before the Christmas holidays and so on. Certainly wouldn't like to be doing it the first week or so in January either. But so it's the first half of December. There shouldn't be a difficulty with that. Okay, I was talking about the structure of the hearing and the evidence and estimated timescales. One of the key issues that I have gleaned from reading the response to the procedure notice that we received from Muirhall Energy is the Energy Networks Association document about the separation between wind turbines and overhead lines. And from the information I've got very helpful drawing from Muirhall Energy showing the line of the way-leave, superimpose on that the standoff distance from turbines 7, 8, 9, 10, and 11, 12, and 13, which are either on or very close to that. And that gives me some indication in my own mind about the nature of this. And clearly what seems to be apparent to me is it's almost a test of Energy Networks Association's guidelines and principles of good practice on the relationship between wind turbines and overhead lines. In the documentation I've got on file, I only got the first 4 pages submitted to me, which certainly gives me a flavour of the document, but it doesn't go nearly so far as I'd wanting to see. The whole issue about topping distance, prevailing wind direction, line design, availability of mitigations, limits of deviation, etc. And also the annexes of wind turbine wake designs, etc. So there's a lot of technical material in that, which I don't have. And again, as a note to the meeting, I will be expecting a full copy of that, Gemma, and that to be circulated to parties as well.
Of course, that's no problem. I did notice yesterday that the copy which had been submitted was incomplete, and that it was just an administrative error rather than anything intentional.
That's fine. I thought it was too good to be true just to have 4 pages of it. I no doubt there's quite a lot in there that needs to be looked at. And from my reading of what I've got, that document seems to be at the heart of matters, and it's obviously a very important document. And if we proceed, I would want to spend some time discussing that, discussing its status, discussing its consequences, and discussing mitigation options, especially in the context of the drawing, which is entitled Glen 2 Development Area, and showing that way leave and those turbine locations. And just for my own edification, are there other turbines other than 7, 8, 9, 10, 11, 12, and possibly 13 affected? Am I correct thinking it's just those ones?
In terms of direct impact, yes, they are the ones for SSE's, Scottish Hydroelectric Transmission's policy on the 3-rotor diameter. However, as will have been noted in our response to the reporter's queries, the impact is actually much greater for that southern section of the wind farm as the sky reinforcement line intersects the development. The impact on that from a planning application perspective would be considered to be potentially significant too, in terms of the developer's ability to develop out those wider turbines. So whilst the direct impact from the internal policy being advanced here would have that impact on those turbines, as I say, the material impact would be much wider.
Yes, I do, and I've read in detail your response to the procedure notice, and certainly get the inkling of a lot of discussions on that as well. Can I take it that MEL don't have any interest at all in Mr. McDowell's interest in let's call it the Western Woodland? I mean, the procedure notice was deliberately worded very, very similarly, but I've not had a response on that, on the notice. The response I've got simply relates to way leave 270-35, which is the larger one, but nothing on 270-23, and I don't know whether you know any reason why that hasn't come. Or disappointed Mr. Hall's not here either to answer that.
Just for clarification, do you mean in terms of a response from the landowner themselves, or do you mean on behalf of the developer?
Yes. No, well, it would go to the landowner, that one.
If he was here, okay, of course. Apologies, no, we don't. We are in dialogue with Mr. Hall relatively regularly, so we're happy to raise this. I know you've mentioned it, but unfortunately, I'm certainly not aware of why they've not responded to that. And maybe it'll be that there's perhaps some confusion, and you think the response translates across. But I think we would have to clarify that ourselves. One size
fits all. Yeah.
Yes.
Yeah, right. Okay. Well, I certainly like some clarification on that. But I think certainly in my determination to make a recommendation to Scottish ministers as regulator in this particular case, that document is a very important document, and I would certainly want to spend some time going through it on that and understand its status in the eyes of the applicant as well as the wider world, if you like, on that. So I'd welcome a full copy, Gemma, when it's possible to get, and I'll make reference to it in my note of the meeting in due course.
That's no problem.
Right. So the next, so that in terms of the structure of the hearing, that's going to focus quite significantly. There are other issues which are referred to in the response to the procedure notice from MEL, and talked about the impacts of Glen and what you're saying is the consequences of the grant of the necessary way leave. If ministers were to grant it, the consequences of the ultimate generation capacity of the wind farm, and so on. And that's something I would wish to go through as well. In fact, I think the structure of the hearing is going to reflect very much on the MEL response to those points. And as I suggested, it's not going to be over in the course of a morning, put it that way. I estimate it may well take 3 days to go through all this. I could be wrong, it could be less, it could be more, but that's my estimate at the moment. Does anybody else have any feeling in terms of how long they think it will take?
From the developer's perspective, I think 3 days sounds sensible. I think in order to, as referenced earlier on, I think fully understand it, I think we would need that augmented hearing statement from the applicant to really understand how much we're going to have to get involved in that. But 3 days, certainly from our perspective, sounds sensible. Just before we move on, I think the one thing we were talking about dates there, and certainly mid-December could work for us. Certainly, as mentioned, and I don't know whether we skipped to agenda item 3 or if I know Gemma kind of covered it off potentially with the kind of discussions are ongoing. That certainly is the case. From our perspective, we've been keen on assist because we do feel that we have reached a technical solution with the applicant and that we should be able to, between ourselves, resolve that. So I think potentially, as we've mentioned, the focus of all the parties here would be to benefit everyone, would be to focus on that rather than, no doubt, the large amount of work and resource and time that would be required to prepare for a hearing at relatively short notice if it's within 6 weeks. So I think from our perspective, we would like to suggest that I can assist actually of kind of 4 to 6 weeks to allow parties to focus on that would actually be a useful next step in the process.
Okay.
As I said, we have raised that a couple of times with the applicant, and we know that the applicant has its position on that. As I say, that will form part of a bigger dialogue about what this process is for and what's been advanced here. But I think I would just like to circle back to, well, that point around when the hearing is, our position on it, and obviously December could work if that is ultimately what was decided. Mr. Norman, as I say, coming back to agenda item 3, which was covered off very briefly, I think actually assist in this instance would be useful for everyone and save considerable resource, time, and ultimately expense, certainly from the developer's perspective.
Right. Okay. Well, I was wearing several hats when I was looking at diaries in the end of November, beginning December, because I'm mindful, on the one hand, that these two applications have been around for some time. I'm also mindful that MEL's application is with energy consents at the moment, and I'll come on to discuss that at the present time. But clearly, how ministers determine these way-leave cases could have impacts on that application. And we're also very much mindful of the need to expedite the renewable energy in terms of being reflected in NPF4, etc. So I thought, giving it the benefit of the doubt, I try and get the hearing done this side of the turn of the year. I mean, I'm a wee bit worried about talking about meetings in December, and a week steps we end up Christmas holidays and people's availability becomes much more difficult and so on. And I'm not overly confident that shifting it from the end of November to say the middle of December is probably in practical terms better, whether it'd be better to have a clear start in January rather than try and do it when people's leave commitments and other commitments in the run up to Christmas holidays and so on start impacting on it. Also from Scottish ministers, other hat, Douglas, your feelings about assist into, I mean, as I say, I'd be uncomfortable by moving it forward to middle of December, because I think there's practical terms in terms of circulation of documents and people's availability and etc. I'd rather have a fresh start and make that in early January, which, heaven forbid, is not that far now. But Douglas, in the first instance, in terms of assisting matters, does that give you comfort or not?
I think what Rippett's position on that would need to be as a neutral one, really, for the key participants in this process and for to express a view on and for you, sir, to take a decision. But I could be perhaps persuaded to go further than that and say I can see sense in allowing time to focus, the key parties to focus on achieving a resolution. That said, I can see why that would need to be supported by both of the key parties, because there are conflicting interests here. That's definitely the case.
Okay, well, just from the applicant's perspective, sir. So we've already had discussions with the developer with regards to assist, and the applicant's position has been made clear that we are already, the process has been quite slow already. For an example, we submitted the statement of case or written submissions for Mr. McDougall's interest in June. So the applications were submitted, in spring this year. So for us to go beyond the end of this year and the decision thereafter could start to have an impact on the programme of the potential works.
Yeah.
So it's for that reason that we're trying to reach a middle ground by having a hearing far enough out that we believe that if parties put their minds to it, that we can reach an agreement in that time, but not putting a pause on it for it potentially to run into next year.
Right. Well, in that case, let's go for I don't have the exact dates in front of me, but around the middle of December, and I get some confirmation of dates. And I think I'll look to reserve 3 days for it on that. If it needs to go into a 4th day, I understand at the moment that's possible in terms of timetabling for these facilities. But I can appreciate, Gemma, by putting this back into January, and I'm very keen to get the decisions out on these 2 cases anyway. But I think that's helpful. If everyone is minded that we would not have the hearing in November, but middle of December, 3 days then. Was that an agreement with parties?
Thank you.
Don't hear any voices of dissent. Okay, because other things that I'd want to discuss at the hearing, and as I intimated, the very full response to the procedure notice that's been received, and very illuminating for me. Much of it is focused on Glen Ullinish to lay out turbine types, etc. Now, I also, wearing another hat, appreciate that occasion hasn't formally come to us yet, and indeed, pending the position of Highland Council, it may not. I mean, obviously, if Highland Council don't object to it, there may well be pressures. If I don't know what position of Nature Scott and local communities is, etc. But that application is not here yet, and I'm conscious that it's potentially not something that the developer would wish in the public domain at this particular time. I don't know. You may have a view on that. But I do have specific questions on the wind farm. I've seen the drawings that you've submitted showing restoration and woodland, etc. I'm conscious that the turbine that you're proposing is termed a candidate turbine only at the moment, and that not all candidates get elected at the end of the day, and clearly the final decision on the turbine may have implications for the three turbine diameter issues for the line of the Way-leave and the impact on the on particular turbines and so on. Part of the first question is, are you happy to let me see the full Glen Ullinish environmental impact assessment? On the assumption it's with ourselves here. I'm not. I stress at the outset and underscore again, I'm not here to cast any views whatsoever on Glen Ullinish 2. That is a due process the proposal has to go through, but it does clearly have implications buried in the response to the procedure notice, as if ministers were to refuse the Way-leave or grant the Way-leave, there might be knock-on effects on the turbine. And you've raised the points as well that the contribution from the revenue for grid transmission, I think it's 67% of the needs case for the refurbishment of the line. So there's clearly a link between the two. And I want to have some understanding of what the wind farm is in a technical point of view without making any assumptions as to the final consented stage on that. And what I would propose to do is set out, well, first of all, I asked the question, are you prepared to let me have a look at the full document? Is it available elsewhere on Energy Consent's website or not? Or if not, I certainly wish to see details of turbine construction, laydown, and also limits of deviation from the applicant as well, because obviously that drawing on the plan could move either way once you do a geotechnical assessment of that. So in a nutshell, what I'm saying is, would it cause consternation with MEL to send me a copy of the environmental statement?
No consternation whatsoever, absolutely not. It is available on the ECU website, Mr. Norman. However, we can also prepare a hard copy if that's required, and would assist.
Yeah. Well, I would say a hard copy would assist greatly. I mean, particularly looking at land areas, and certainly the plans I've got for the way leaves is of such a scale, it's really quite a complicated jigsaw to put together to know exactly where we're at. But a hard copy of the EIA certainly would be something that would be of benefit to me in understanding this. And from that, I can see quite clearly where the turbines are in Scottish Minister's land as well, and I can see the big picture, and that would be grateful. In the same way as a hard copy of the full Energy Networks Association documentation on standoff. And I've put all this in the report, but that would be helpful, and I thank you for that. So in terms of other evidence that I would like to talk about on that are the options that MEL suggest, point 2 in the response to the procedure notice. And in that, you're saying you give 4 options that the applicant could consider. One is the redesign of the route, located so no proposals are affected by the 3 rotor diameter buffer zone. The other one is to require Scottish Hydroelectric not to strictly apply as termed their policy. I want to come on to their policy, whose policy it is, but not to apply that. Have further discussions about mitigation, or the 4th one is undergrounding in the key areas. Okay, and what I would want to do is to have a session on each of those options, so that when I compile a report to ministers on the way leave, those options are understood by myself, and that's addressed as well. Okay, that may well take much of a day to do, depending on the outcome. And yeah, I need to fully understand the consequences for the wind farm if I was to recommend to ministers to grant the way leave. Okay, you're making reference in the very helpful response to the procedure notice on the financial aspects of that, and financial aspects are not central to my consideration, but bearing in mind the tests I've got to assess the way leaves are necessity and expediency, and there's a discussion to be had about what does that mean in practice in this context. But clearly I'm aware of the stage of the planning application for the wind farm, or the deemed application, where that's at the moment, and your anticipated timescale for determination. That's obviously critical to key pathway for construction, etc. So again, I put that in the note, but I think I would want a fairly significant session at the hearing on the implications for the way leave of Balmeanach 2 wind farm, and indeed the way leave through the land, the other bit of woodland as well. Okay.
Sorry, sir. Might I also suggest that Muir Hall include within that the implications for the wind farm if the way leave is not granted and the line is not constructed?
Yes, I have asked that. Now, I think I would come into that. There's a bundle of concerns about that. But if the way leave isn't constructed, the implications for the wind farm as well.
Yeah, thank you.
And bearing in mind, I've read, not in detail yet, but I've read the needs assessment which you submitted to Ofgem, and I've seen the Ofgem response, and I'm aware of the wider implications for the Skye project, not just for the island of Skye, but the connections to Harris and Lewis as well on that. And I would be looking at the implications of me recommending that it's not constructed for whatever reason.
Thank you.
Okay, is anything else under those headings of structure for the hearing, participation and dates? I think we've covered those.
No, I think that's covered everything.
Yeah. Right. Next item, an update on the proposals for Glen wind farm. As far as you can say, as I understand it, it's with energy consents now. They consult with parties, the principal party being the Highland Council, obviously Nature, Scott, local communities, etc. as well. Have you any idea when you may expect a determination, or whether it'll be referred to us and a reporter or reporters who won't necessarily, or probably wouldn't be me, would handle that case? Have we got any timescale for that?
I don't think we do at present. I'll rely on Kirsty nodding or shaking her head. I don't think we have an indication on the timescales. My understanding is the consultation period is ongoing at the moment with the statutory consultee responses, and I think that's as far as we know. Otherwise, we're in the hands of the local authority for the time being until they have their committee date.
Is that committee date being set yet?
Not as far as I'm aware. Kirsty, I don't know if you're...
Okay.
We're just in the process
Right.
of discussing timescales with them just now.
Right, and that would go to their area committee, and that would be a recommendation to either object or not object. Kirsty, that's the position.
Yeah, that's correct.
Yeah. And are you able to say what statutory consultees' comments have been? Nature, Scott, or local communities, etc.?
So at the moment, Historic Environment Scotland and Nature Scott have extensions to the consultation period, so we're expecting responses from them in November. The only other statutory consultee that we've received a response from is SEPA, and there's some requests for further information within their response, so it's likely that we will have to submit additional information, but we're engaging with consultees just now.
Right, it's ongoing. Right, thank you. Right, well, that brings us neatly to item 8 on the agenda, which is the prior disclosure of cases. And I think I made in some of my opening remarks an hour ago that it's a fairly rapidly moving fluid situation at the moment, in particular the further discussions parties wish to have, and consensus about assisting or potentially assisting, and further dates. And I certainly sense that to look at dates at the last week of November may be premature as things stand at the moment. Please, if anyone disagrees with what I'm saying, do speak out. Prior disclosure of cases is not simply just submitting the written observations that the applicant did, as it happened several weeks ago now, but is to look at everything in the case for it, which will obviously have to include consequences of other discussions, and heartened to hear that it may well be that consensus is found on this. And again, the 4 options as suggested in the procedure notice response are in my head at the moment, but it may well be there's 5th or 6th options, which could be result in agreement being found. So there will need to be prior disclosure of cases, but I think the cases that I've got in front of me are not fully complete at the moment, and they may require augmenting, and that's going to. So what comes first, the tail wagging the dog here? I've said that we'd look to mid-December, mindful of Gemma's comments on the time this is round, but that may slip, and it may well get entangled with Christmas and New Year holidays and so on. But certainly before the hearing, there needs to be a disclosure of cases, and it's not really possible to say by when yet. But I certainly look to have cases disclosed at least 2 weeks before the hearing is starting, so that opposing parties can have time to comment on the opposing case. So there's probably not much more to say, but just to not forget that there's a timeline in there. And again, a site inspection, I do want to see the site in some detail, and picking dates to see aspects of fairly wild and remote countryside is in December. It's got its own, potentially got problems. But before a date commences for the hearing, I would want to see the site, and presumably I would want that to be accompanied, and presumably transport off-road can be arranged for that at some stage in the proceedings. But not to forget that it would be foolhardy of me to start the hearings without seeing the site as well.
Sorry, if I may comment
Yep.
just very briefly on 2 points. First of all, from a practical perspective, I'm sure I can speak on behalf of Bill in terms of offering assistance for your site visit to those parts of the site which are owned by Scottish ministers. Also, in terms of prior disclosure of cases and the conversation we had a while ago about your procedure notice having some specific questions for RIPID, I think this point, and again, Gemma had mentioned a while ago by way of response to my remark about necessary way leaves not being capable of being granted, imposed on Scottish ministers. If there is a point being taken about that, that's something which I suspect would be helpful for us all to know what parties' respective positions on that are. Now, on the other hand, obviously the mood music during this meeting is we hope that a resolution will be achieved, meaning that isn't the issue which it is today. But if it is to remain an issue, it would be helpful to know what parties' respective positions are on fundamentally what is a legal point. And that I would think is a helpful thing to explore earlier rather than later in the process. Another point for you to consider, sir, I would suggest.
I hear exactly what you say there, Douglas, on that. It's foolhardy of me to say I sense the way things are going at this stage, but it may well be that agreement will be met, and the hearing may not need to take place. As things stand at this point in time, it does, and we're coming up to a difficult time of the year for that. I think mindful of what the applicant has commented, I'd be reluctant to kick it down the road as far as the 2nd or 3rd of January. I think we should be looking at middle of December, which after all is not that long ago now. We're nearly into November. But I would certainly want, before it starts, parties' disclosure of cases to be available for opposing sides before that. So we're probably talking realistically by the end of November, to allow a 2-week feed-in time before the hearing starts. Prior to that, you may have internal discussions. So I think the timing is on our side for that. The issue about the legality of a necessary way leave with the Crown is really out with my scope of this meeting. It's not been raised in the correspondence on the 2 way leaves in front of me, because that land, to the best of my knowledge, that land with Scottish Minister's ownership hat is not included in these 2 way leave boundaries, but clearly it's on the other side of a fence, on the westernmost one, and it's an integral part of the actual Skye refurbishment programme. But I think that discussion should take place at arm's length of these discussions and not impede looking at the hearing date of around mid-December. Is everyone okay with that?
Well, I think we're okay with the hearing date being mooted as middle of December. I do think, just picking up on Douglas's point there and what had been discussed earlier, certainly what we had took from the earlier discussion was that the applicant was going to update their hearing statement, certainly to address the kind of change in position. Obviously, at the moment, they have a position which is that the Scottish Minister's land is secured by way of a way leave. that has obviously changed, and I think that is, from the developer's perspective, and we would imagine from the decision maker's perspective, that is a fundamental change. So whilst it might not be the land that is affected in terms of that overall decision making process, I think we need to understand how the applicant proposes to address that issue. As Douglas has mentioned, as a significant legal point that needs to be addressed. And I think we would be looking, certainly, as mentioned earlier on, for that to form a large part of the hearing session. And I think in the absence of that being addressed by the applicant, I think we really struggle to see how a recommendation could be made to, again, my point earlier on about the deprivation of rights for the landowner and the developer here, where there is actually no prospect of success for the applicant to actually develop out their line as currently proposed.
I'll let Ali jump in there. He's got his hand up.
Thanks, yeah, but it is worth just pointing out that while the Scottish ministers have issued a letter to terminate current voluntary way leave, that voluntary way leave does stand for a period of 12 months. And within that period of 12 months, the applicant potentially has the ability to seek a necessary way leave. So I think it's just worthwhile pointing that out, that the valid way leave still remains, albeit there is a termination submission submitted by the Scottish ministers.
I suppose, Ali, if I may address you directly, that's, again, I'm here to be sort of neutral through the whole thing and see what I can suggest on behalf of RIPID and ultimately to assist the reporter. Is what strikes me is there are so many different aspects to all of this. We have 2 necessary way leave applications. We have a contractual way leave, which, as you obviously very correctly say, notice to terminate, a 12-month notice to terminate has been issued. There may or may not be procedures which could follow on the back of that notice of termination, and the contractual way leave sits covering an area out with the scope of the necessary way leave applications. I'm struck how by the fact there's ample room for confusion around what's going on, and I just, for my part, sitting a little bit away from this, albeit having a key role, is that attempting to set these matters out and how they all relate to each other may ultimately be of assistance to the reporter in understanding that bigger picture, which I understand Mark keeps taking us back to.
I certainly would want. I certainly would want to see the bigger picture, because there's question marks over whether ministers could do or ought to grant these way leaves if they lead to nowhere, which I think would be the effect of not being able to keep that way leave in place in some form or another. I would certainly want part of the hearing to look at the implementation of the refurbishment project in its entirety. And bearing in mind, this is a report that has to go to ministers, it would be remiss not to refer to the, for want of a better word, gap westwards of the 2 necessary way leaves in front of me. I mean, I can't second guess the outcome of discussions between the Scottish ministers, RIPID, land ownership, the applicant, and Muirhall Energy, and it wouldn't be proper for me to try and make an assumption on that.
If I could just respond briefly,
yeah, go ahead.
sir. As you've already pointed out, the events in relation to the Scottish Minister's way leave are relatively recent. So we are still considering our position. But in terms of the overall application of the Scottish Minister way leave area to these way leave applications, I have to admit I'm struggling to see the relevance. It's, as far as I'm aware, it's entirely normal for different applications for the same project to be heard, in some cases not on a conjoined basis. Some may naturally fall out of step with the process. And in my mind, this is where we are with this. We may have another application which may be submitted, but I fail to see the relevance for this application, which specifically relates to the occupied area and Mr. land ownership. So I would suggest that whilst we're happy to address it to a certain degree in the hearing, I'm not sure there would be much merit in taking up a large amount of time discussing what is actually an issue for a separate matter.
In any event, things might have changed in 4 or 5 weeks.
Exactly.
From what I'm hearing anyway. Okay, I note the points you're making and I reflect on those. I think I'm inclined to still look at a period of mid-December for 3 days. If it needs to be a continuation to wrap up outstanding bits at the end of that there will be time. It's not a total impediment to say it's got to be 3 days, but I'm reluctant to address a situation that may well resolve issues. And I was very heartened by comments earlier on about agreement being met. And presumably you can get to some stage before the timeline for the submission of disclosure of cases to reach that agreement, because that open-ended unknowing what's happening can't go on forever, and it would consequently result in the hearing being reallocated into sometime in January, which doesn't, I think, suit anybody's interests. So if I could ask that.
Sorry, sir. Parties are, I would say, committed to reaching an agreement. There are draft documents outlining the agreed position. They're currently sitting with us, but I hope that the next version can be issued this week. And as far as I'm aware, there's not an awful lot still in dispute between the parties. If we can formalise what has already been agreed in principle, then I would like to think that we could get it over the line relatively quickly, subject to discussions on two or three, the wording of 2 or 3 points.
Well, as I say, there is a timeline that I've got to look to. If we're looking at, say, just picking a date out of the air, 14th of December, sometime 14 days before that, there's got to be disclosure of documents. That's obviously going to be drafted and checked and so on. So it's quite a compacted timescale to see, but certainly I would look to ask parties to expedite some agreements so we all know where we're going on this, and we don't end up booking slots and it terminating on the evening beforehand when so much work has been done by everybody on that. So if I could ask that parties expedite a sense of agreement, that would still leave the issue of Scottish Ministers' land, but I think that's a separate discussion to be had specifically on that. And I may not need to make recommendations to ministers on these two. But all I would ask is parties really pull out the stops to try and get some agreement as soon as possible, and just for programming our own workload as well, because if we do go down the route of the hearing, it's a fairly significant chunk of my work, and there's no shortage of way leaves waiting in the wings within these 4 walls to be resolved as well. So if I could ask matters are expedited, whatever way it's going, as soon as possible, that'd be very helpful. Thank you.
Could I just make a clarification on site visits, please? So just to confirm that what Douglas said, we would be happy to facilitate that, but the site itself is very large. It's bounded by public roads, and there is a road running up through the forestry to one of the crofts. But the central area is effectively accessible only by foot. So there would quite rightly need to be a level of planning around accessing that, particularly bearing in mind climatic challenges in late November,
hours of darkness, etc. Yes, absolutely.
December.
Yeah.
So if you are If you want us to facilitate a site visit, that's absolutely fine. But we would need to engage with you in what you're after and where you want to go to help facilitate that. Okay.
Well, certainly I would want to know and have an idea in my own mind the locations of the turbines to be sited upon Minister's land and the route of any way leave. But that may or may not need to be any more than a sort of superficial overview in the event of some resolving of the other two cases. If there is to be further legal procedures on the Minister's land, that's going to be subject or maybe subject to a separate application, and that would be for another day to see it. But I would certainly wish to get an overview, conscious that Skye doesn't, lovely place that it is, doesn't have that much daylight in December and usually has pretty poor weather to supplement that. But I certainly wouldn't be anticipating walking the length and breadth of the land, that's for sure. What I would want to do if we are going towards the hearing is to see the site, particularly the areas shown on the Muirhall Energy drawing where the indicative line of the way leave and the buffer zone of turbines 7, 8, and 10 and 11 are shown on that. And question, think through how we do that on that. But certainly in terms of Minister's land, because I'm not dealing with a way leave application for it, I just need an understanding of the boundary and where the overlaps to be on that.
Ali, did you?
Okay.
Yeah,
No.
just to add to Bill's comments, we can facilitate access in terms of ATV access to speed the process up for the relevant parties that require to go to sites, so we can engage with the tenants and obviously the Scottish ministers to ensure we can get safe access to the sites.
Yeah.
So,
probably the best thing to do is have two or three potential days, because you can bet your bottom dollar the day we'll pick will be another named storm passing over and it'll be dark at 2 o'clock in the afternoon or something. But if we could have 2 or 3 potential days for that, and I can organise that from this end of getting there. Okay, is there anything anybody else wants to raise? We've covered a lot of ground on that. I've got the draft minute of the meeting to circulate parties for comment before it becomes formalised, but it certainly really helped my understanding of matters. I'm a bit of a loss about the position of Paul Baird and the procedure relating to the other way leave on that, but that's for another day for me to resolve. And has anyone else got any other business to raise?
Not for me, sir.
And if that's the case, we'll formally close the meeting just before 11:30. I should get a note of this probably within a week to 10 days time in terms of time scales and so on. I now in our diary for these facilities, and that can be fluid if it needs to be brought forward. It can be brought forward at the moment or postponed until January if it needs to be. Okay. Thank you. Thank you.
Yeah, thank you.
Thanks, everyone. Thank you.
thank you.
Thank